this time around, Hank Brennan seems intensely focused on putting Karen Read squarely under the spotlight. And the way he's going to do that, amongst others, is by using her own statements. All eyes turn to a Massachusetts courtroom for the highly anticipated trial of a woman accused of murdering her police officer boyfriend by running him over with her SUV. Plus, the Arizona conspiracy and murder trial of the so-called Doomsday Mom nears its climactic end. And two brothers convicted for the 1989 brutal slayings of their parents are back in court for a contentious hearing to determine if they will ever see the outside of a prison again. All this and more this week on Courtroom Confidential. This week, the gloves are off in several of the trials that we have been following closely. There's a lot for us to dive into. We are recording this episode on Friday, April 18th, 2025, and this is your Courtroom Confidential weekly roundup. Let's jump in. Opening statements in Karen Read's high-profile murder retrial are set to begin next week, with both sides presenting their cases to a newly seated jury of 9 men and 9 women. Read has pled not guilty to second-degree murder, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death. Prosecutors allege she struck her boyfriend, Boston police officer John O'Keefe, with her SUV during a snowstorm in January of 2022, following a night of drinking. Her defense claims he was killed during a fight inside a fellow police officer's home and then left out in the snow to die, alleging a cover-up involving multiple law enforcement agencies. The prosecution, which has long said it will use Read's own words against her, appears poised to lean into that strategy from the start. Before and after her first trial ended last year with a deadlocked jury, Read has given numerous media interviews. This week, Special Prosecutor Hank Brennan turned over 41 audio and video clips. Among them is a 15-second clip Brennan plans to show the jury. Judge Beverly Cannoni viewed it privately during a pretrial hearing on Wednesday. When asked outside of court if she had seen the clip, Read responded that she had, and that it revealed, quote, nothing that phases me in any way. Read's defense plans to reuse 2 experts from her first trial who testified that John O'Keefe was not struck by a vehicle. While initially presented as independent, the experts were later paid and are now directly hired by the defense, possibly for further testing. Prosecutors want to know if the experts' opinions have changed, and the judge has ordered the defense to turn over all communication with them by Friday and disclose any plans for additional testing by Monday. Separately, a central figure in the case's media firestorm, blogger Aidan Carney, who goes by the name Turtle Boy, invoked the Fifth Amendment in a private sidebar with the judge. Carney, who is charged with witness intimidation in connection to the case, acknowledged that testifying could incriminate him. As a result, the prosecution agreed not to call him to the stand. He will be permitted to attend most of the trial. The prosecution also raised concerns about the defense's dog expert, Garrett Wing. Brennan noted Wing's lack of formal certification and courtroom experience. In response, defense attorney Robert Alessi said Wing is one of the country's leading experts in law enforcement canine training. Opening statements are set to begin Tuesday morning for the trial, anticipated to last 6 to 8 weeks. All right, well, what's happening here? If you are like me, you are ready for this trial to just go ahead and get started already. We have seen a lot of fighting. Not 1 inch of ground is being given by either side in this case. And by the way, that's good. That's the way it should be. I applaud all of the advocacy on both sides of this case, but I'm also exhausted and I'm just ready for it to start. Obviously, there are going to be some differences this time around than there were the first time around. First of all, we have different players involved. We have this special prosecutor in Hank Brennan. I think he has demonstrated that he is very smart, that he knows this case well, and that he is a fierce advocate. And on the other side, we have a new addition to the defense team with Robert Alessi, who is equally as prepared and smart and well-spoken, and he's going to be quite an adversary as well. But the biggest change, in my view, is what role is Karen Read going to play in this new trial? What do I mean by that? How could she possibly take a bigger role, you may be asking yourself? She's the defendant. But think about it. In the first trial, I feel like her presence in the trial itself almost became non-existent. It was lost in this sea of accident experts and police misconduct and dog bite evidence. What role Karen Reed played in all of this seemed to kind of take a back seat almost. And even if you don't entirely agree with that, I think you will agree that her role in this new trial will become far more prominent. Now, I know in the first trial, we heard her voice messages. That was a big part of the case. We heard some text messages that she exchanged. We heard, obviously, now the famous words, I hit him, from several people testifying. But it never, in my view, looked as if she took center stage. And I think the biggest difference will be that this time around, Hank Brennan seems intensely focused on putting Karen Reed squarely under the spotlight. And the way he's going to do that, amongst others, is by using her own statements. Yes, the statements that she made to first responders. Yes, the statements in the voicemails. And yes, the statements in the text messages. But even more than that, and perhaps even more impactful than that, will be the statements she has made since all of this began to the media. Some of the most powerful evidence in a prosecutor's hands is going to be words out of the defendant's own mouth. Now, that could be in the form of statements that they gave to investigators. That could be in the form of them taking the stand and taking an oath and testifying in court. That could be in the form of surreptitiously recorded conversations. And here we're seeing an instance that you don't see all that often, which are statements made to the media, many statements, in-depth statements. In the case of a documentary, almost unfettered access to Karen Reed, talking about this case, talking about the evening, talking about her recollections. That is a gold mine in a prosecutor's hands, and they plan on using it. Now, you may be thinking, I've heard all those statements. She didn't make a confession. She never says, I hit him with my vehicle. How could that possibly be helpful to the prosecution? It's about more than that, though. It's about nailing down certain narratives of what has come out of her own mouth about what she said took place, about her recollections, things she remembers from that evening, and how her defense team now cannot pivot from that. They're stuck with that because those words came out of her own mouth. Jurors love this kind of stuff. For as long as I have been practicing, one of the hardest things to convince jurors of is why a defendant might not testify. Because people just have this built-in feeling that if I were accused of something, I would be telling you about it. I would take the stand and I would testify about it. And trying to get them to understand that a person's not going to testify and they have the right to remain silent is very difficult. From both a prosecutor and defense's perspective, to explain that to jurors so that they can be fair-minded jurors going into a trial. Why is that? Think about that. The reason is human psychology. We want to hear from the accused person. So like I said, if it comes in the form of a surreptitiously recorded conversation or in the form of prior recorded interviews with investigators, or if that comes in the form of them testifying, those words are going to matter to jurors and they believe them and they hang their hat and verdicts on them. And in this case, that might come down to some of the statements that she made to the media. How impactful are those statements going to be? What light do those statements shed upon Karen Reed? It really is going to be, in my view, the biggest change this time around. But what do you guys think? Or what do you expect to be different this time around? Please let us know in the comments. The prosecution and defendant Lori Vallow Daybell have rested their cases in her Arizona murder conspiracy trial. The so-called Doomsday Mom is accused of conspiring with her late brother, Alex Cox, to kill her fourth husband, Charles Vallow, in 2019 in order to collect life insurance money and marry her religious leader, Chad Daybell. the state concluded on Wednesday after calling its final witness, a Chandler police detective. Over the course of 7 trial days, prosecutors presented testimony from 19 witnesses and introduced a large volume of evidence outlining an alleged conspiracy between Lori and Alex Cox. Key evidence included text messages between Lori and Chad Daybell revealing religious undertones and references to Charles Vallow being a, quote, dark spirit. Prosecutors highlighted Lori's reaction to not receiving the $1 million from Charles Vallow's life insurance and how she sent photos of the beneficiary change to Chad Daybell. Jurors also viewed surveillance video from the day Charles Vallow was killed. In the footage, Lori is seen buying 2 pairs of flip-flops at a drugstore shortly after picking up food for her son, JJ Vallow, from a drive-thru. Her daughter, Tylee Ryan, was with her. Witnesses described Lori's demeanor following the shooting as, quote, nonchalant. Prosecutors also highlighted that she never called 911 and had Charles's phone with her, which, alongside her own device, allowed police to track her movements. Chandler Detective Ariel Weather walked jurors through the timeline, but during cross-examination, Lori was reprimanded by Judge Justin Boreski for veering off course by inquiring about Charles's dating life. Quote, whether he went on dates or had dates scheduled is not relevant to this case. Ask another question, the judge said, responding to objections from prosecutor Trina Kay, adding, quote, you can ask about the date of the person who testified the night before because that person was in here and had some relevant information. But other than that, any of these other questions are not relevant. Lori said she intends to rest without calling any witnesses and, to the surprise of many, will not testify herself. Lori has already been convicted in Idaho of killing her 2 young children, JJ Vallow and Tylee Ryan, and conspiring to murder Chad Daybell's first wife, Tammy Daybell. She's also charged with attempted murder in the Arizona shooting of her former nephew-in-law, Brandon Boudreaux. That case will be tried separately. The shootings of Charles Vallow and Brandon Boudreaux occurred just months apart. Trial will resume Monday morning for closing arguments. Well, what is happening here? The largest question here is, why didn't she testify? Now, there's a slim chance that she still might. She has not formally rested her case in front of the jury, and that is something that needs to happen, and that is the conclusion of your case. That is when it's no takesies backsies. At that point, you're done. But she has not done that, so there is a slim chance she could change her mind over the weekend, come back in and say, you know what, I think I do want to testify. But all indications are that she will not be testifying. So why not? Now listen, the most obvious answer is that the smart legal strategy is that she never should take the stand. She's got prior crimes that are ripe for cross-examination that there's no way any defense attorney would allow a client with her criminal record to take the stand. Now, I know that the judge talked about this and there was some contemplation about sanitizing to a certain extent her prior convictions, but she's taken the stand. There is no way she could perform the kind of high wire act required to not open the door that somehow a clever prosecutor would get in the fact that she was found convicted of murdering her own children. But Lori is not representing herself because she's following sound legal strategy. She's representing herself because she wants to be heard, because she wants to be in control. So why stop all of that now? I fully expected her to use this opportunity as her own personal pulpit. I was waiting for that moment. This is a person who believes that they are smarter, more charming, more spiritually enlightened than anyone else on earth, and certainly in that room. And I thought, she wants the world to know that. That's why she's representing herself. So the fact that we are sitting at the end of trial and we did not see Lori Vallow sit in that witness chair and tell her story is shocking to me. Perhaps she will save much of that for closing arguments, and we will be watching. But what do you guys think? Do you think it might have been a mistake for her not to testify? Please let us know in the comments. A long-anticipated hearing that could give Eric and Lyle Menendez their first shot at freedom in over 3 decades was abruptly delayed Thursday amid disputes over whether a Los Angeles court can access a recent comprehensive risk assessment conducted by the California Board of Parole Hearings. The delay followed a tense courtroom showdown between the brothers' attorney, Mark Garagos, and District Attorney Nathan Hochman. The DA's office, in a filing the night before, urged the court to delay proceedings if it couldn't obtain the complete risk assessment in time, an evaluation previously requested by Governor Gavin Newsom's office. At Thursday's hearing, when prosecutors insisted the risk assessment was relevant, Garagos dismissed the move as a, quote, dog and pony show. When the prosecution called that comment degrading, Garagos fired back, "You should be degraded." Judge Michael Jessic said he needed more information about the governor's office risk assessment report and how it could be used by the court, adding in a revealing moment, quote, "because this is stupid." After a recess, Jessic called both parties for a closed-door conference. 10 minutes later, Garagos returned, gathered his team, and exited the courtroom, followed by around 20 supporters, including Eric Menendez's wife and several family members. Outside court, Garagos said the governor's office had authorized the judge to access the reports, but emphasized the assessments are not yet final and noted a strong desire for them to be used only for the June 13th parole hearing. Eric and Lyle Menendez have served 35 years of life sentences without the possibility of parole for the 1989 murders of their parents, Jose and Kitty Menendez. This week's hearing was meant to determine whether their sentences could be revised to allow for the possibility of parole. That decision would have sweeping implications for the legal team, relatives, and growing online movement rallying behind the brothers, spurred by a resurgence in public interest driven by documentaries and dramatized portrayals of the case. Now, all parties will return to court on May 9th to consider, 1, a recently filed request by the defense to recuse the LA County District Attorney's Office from the case, and on whether the recent risk assessment report can be admitted as part of the resentencing hearing. Judge Michael Jessic said both issues must be resolved before any resentencing can proceed. What's happening here? This is an absolute mess. I mean, it really, really is. Putting aside all of the cameras and all of the theatrics, this is a serious case. It really is. It's a serious case with serious implications. We are talking about whether or not it is appropriate for a defendant, putting aside defendants who've got a long history of media attention, just any defendant who's been convicted for a crime where they will never, according to their sentence, have the possibility of being paroled. And can we unwind that? And can we unwind that not because of a change in the law, but because of a change of the way that we look at the case, a change culturally? That's really where this is coming from. This entire groundswell of support came from people in 2025 looking back on a case from 30 years ago saying, we feel differently about what may have happened to them now than we may have viewed it back then. And because of that, and because of their exemplary behavior by all accounts, since they've been in prison, we think they should get a shot. We think they should have a chance. That's what this is really about. And this case, many, many other defendants are going to be looking at. And if this judge allows for resentencing here, this could have a huge impact on other people who sit in prison on cases where they're sentenced to life without parole. So all of this should be taken with the utmost seriousness. Yet, it's somehow turning into this circus. I mean, I hate to use that word, but we've got allegations being made in court. We've got the defense attorney nearly performing a stand-up comedy routine. We've got the judge admonishing the audience that they need to behave themselves. But let's talk about where we actually stand here. Hochman no longer supports the position of his predecessor, George Gascon. Not only does he not support the idea of requesting resentencing on behalf of the Menendez brothers, he is actively fighting resentencing. And because of that, Mark Garagos feels he's got nothing left to use. So he's going to pursue this scorched earth policy. It's no longer about making friends. It's no longer about asking for cooperation. He realizes where this current DA stands, and he says, all right, well, I'm going to do everything I can at this point. No holds barred. I've got nothing left to lose. So if that includes trying to get the DA kicked off the case, so be it. We are no longer playing nice in the sandbox. Now, is this going to happen? I don't think so. In order to get the entire DA's office recused, you're going to have to show some sort of inherent, built-in bias that blinds them to any kind of justice in this case. And that's not, from what I know so far, what we have in this case. What we have in this case is the DA's office, who just happens to have taken a position that's opposed to what the defense's position is. And by the way, that's how it usually works. So it's no shocker that we find ourselves here, and that being the basis for recusal, to me, is not going to fly. So why do it? If you're Mark Geragos, why do it? Why this shot across the bow? Again, I think he's got nothing left to lose. I think as much of this is a case being fought within that courtroom, it's also being fought outside of that courtroom. They got nothing left to lose. They know they have the support of many people of the community, and they want them to know how upset they are about all of this. And if you're not playing nice with your opposition, then you might as well be playing not so nice with them. One last thing on all of this. I am curious about what exactly is in that report, this recent risk assessment report that has the defense so worked up. This is not the first report they've received about the brothers. This is not the first risk assessment that's been done of them. We know kind of their conduct since they've been in prison. So what possibly could be in this report that would have the defense so twisted up that we're even going to have a hearing on whether or not the judge should consider it? I don't know. And this is more of a question, but it is curious to me that that's where we've arrived at. But what do you guys think? Do you think the DA should be recused in this case? Do you think we've come that far? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask one very small favor, and that is, if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way that we can do that is through your support. And don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, a Maryland jury found a Salvadoran fugitive guilty on all 4 counts in the murder and rape of a Baltimore area mother of 5 who went missing during a run in August of 2023. After less than an hour of deliberation, the jury found Victor Martinez Hernandez guilty of first-degree murder, first-degree rape, third-degree sexual offense, and kidnapping of Rachel Morin. Prosecutors linked Martinez Hernandez to Morin's killing through DNA found at the crime scene, matched in the CODIS database to an unidentified suspect in a Los Angeles home invasion. The jury's swift decision followed a 9-day trial in which the defense called just one witness and presented for only 10 minutes. Morin's body was discovered on August 6, 2023, a day after she vanished from the Ma and Pa Trail in Bel Air, Maryland. Authorities said she was attacked, raped, and killed, then dragged into the woods. It took nearly a year to arrest Martinez Hernandez, who was eventually located in Tulsa, Oklahoma. The then 22-year-old Salvadoran national, who had previously been accused of murder in El Salvador in December of 2022, had entered the U.S. illegally multiple times and was expelled each time he crossed the border in early 2023. He later appeared in Los Angeles after a successful attempt to get into the country, where he was linked to the assault of a woman and her 9-year-old daughter. Martinez Hernandez now faces life in prison without the possibility of parole. Sentencing has not yet been scheduled. A Los Angeles jury has found the wife of an internationally known hairdresser guilty of first-degree murder in the 2017 killing of her husband. The 10-man, 2-woman jury deliberated for just under 9 hours over 3 days before reaching the verdict last Friday, convicting Monica Cementelli for the murder of Fabio Cementelli. Jurors also found true the special circumstance allegations of murder for financial gain and murder while lying in wait. Cementelli now joins her lover, Robert Baker, also convicted of the murder, who was arrested 5 months after the killing. Baker, a convicted sex offender and former adult film actor, pled no contest to first-degree murder and conspiracy to commit murder and admitted to 2 special circumstance allegations last year and is currently serving life without parole. On the stand, he claimed Monica wasn't involved and claimed he murdered her husband because he, quote, wanted her to be around me and with me more, like all the time. Prosecutors argued the pair conspired to kill Sementelli to claim his $1.6 million life insurance policy. A third defendant, Christopher Austin, also pled no contest to second-degree murder and is awaiting sentencing. He testified that Baker told him Monica wanted her husband dead, though he never spoke to her directly. Sementelli is scheduled to be sentenced on June 23rd. A Michigan woman has been convicted for a second time of murdering her husband by setting him on fire and running him over with a van in 2007. After nearly 7.5 hours of deliberation, a jury of 7 men and 5 women found Linda Sturmer guilty of premeditated murder and felony murder. Prosecutors said Sturmer doused her husband, Todd Sturmer, in gasoline and set him ablaze after he discovered she was having an affair. As he tried to escape, she ran him over with their van. Sturmer was first convicted in 2010 but was released in 2018 after a successful appeal citing prosecutorial misconduct and ineffective assistance of counsel. At her retrial, Sturmer's defense argued the fire began accidentally from one of Todd's oil lamps and that she hit him with the van while fleeing to get help. Following the verdict, the judge revoked Sturmer's bond. She was handcuffed and led out of the courtroom in tears. Her current husband, Arthur Breen, whom she married just weeks before the retrial began, vowed to appeal. Sturmer's daughter, Ashley Gibson, who supported her mother while her brothers testified against her, said the trial was unfair and vowed to stand by her despite the jury's decision. Defense attorney Wolf Mueller called the verdict both surprising and deeply disappointing. He maintained the state had not proven arson and insisted there was still reasonable doubt about Sturmer's guilt. Sturmer is facing life without parole at sentencing set for May 19th. A federal grand jury in New York returned a 4-count indictment Thursday against the man accused of shooting and killing a healthcare executive on a Manhattan sidewalk. The charges include 2 counts of stalking, a firearms offense for use of a silencer, and murder through the use of a firearm, a charge that makes Luigi Mangione eligible for the death penalty if convicted for the murder of United Healthcare CEO Brian Thompson. Mangione is accused of stalking Thompson outside the Hilton in Midtown Manhattan and then shooting him to death on December 4th, 2024, as Thompson was on his way to an investors' conference. Mangione was arrested 5 days later in Altoona, Pennsylvania. Attorney General Pam Bondi has previously signaled her intent to pursue the death penalty. Earlier this month, she issued a press release announcing the decision, saying she ordered it to, quote, carry out President Trump's agenda to stop violent crime and make America safe again. Mangione's defense team is now pushing back. In a motion filed last week, attorney Karen Agnifilo argued that Bondi's public statement made before Mangione was even indicted was improper and prejudiced the grand jury process. Quote, the stakes could not be higher. The United States government intends to kill Mr. Mangione as a political stunt. Mangione is expected to appear in federal court on Friday, April 25th for arraignment. A 74-year-old Orange County Superior Court judge fatally shot his wife after a day of drinking and an escalating argument, a prosecutor told jurors Monday at a retrial for a case that deadlocked just last month. Jeffrey Ferguson is accused of killing his wife Cheryl in their Anaheim Hills home on August 3rd of 2023. In March, a jury deadlocked 11-1 in favor of conviction on a second-degree murder charge. Prosecutors say Ferguson, who regularly carried a Glock in an ankle holster, had been drinking throughout the day, first at lunch, then at home, and later at the El Cholo restaurant, where he had margaritas during dinner with Cheryl and their adult son, Philip. The argument stemmed from Cheryl's frustration with Ferguson's son from a previous marriage over a missing thank you card. During dinner, Ferguson allegedly pointed at Cheryl with his hand like a gun, upsetting her so much that she walked out to cool off. She was killed by a gun expert, Senior Deputy District Attorney Seton Hunt told jurors, adding that Ferguson violated concealed carry rules by drinking. Defense attorney Frances Prizia described the couple's dynamic as, quote, normal bickering after decades together. She said Ferguson's finger gun gesture was a way of saying touche. When the argument continued at home, Ferguson thought he heard his wife say, quote, why don't you put that gun away, Prizia said. He's intoxicated, Prizia added. That statement was confusing to him. He thinks whatever makes her happy. While trying to place the gun on a cluttered coffee table, Ferguson's injured shoulder, which is missing 3 of 4 tendons, gave out, causing him to fumble the weapon. As he tried to regain control, the gun fired, according to the defense. This is about an accidental discharge ending in death, Prizia added. Their son, Philip Ferguson, took the stand this week, testifying that when the family returned home from the restaurant and his parents continued arguing, he heard his mother say, "Why don't you just point a real gun at me?" He told the responding officers that night, quote, "That's when he pulled out a gun. I turned around just as the gun shot." The former wife of the accused Gilgo Beach killer is questioning how her hair ended up on the bodies of several victims, her attorney said Tuesday. Asa Ellerup, formerly married to Rex Heuermann, attended this week's hearings focused on the admissibility of DNA evidence extracted from those hairs. Heuermann is currently charged with the murders of 7 women from 1993 to 2011. Prosecutors believe the hairs were transferred to the victims' bodies from another surface and have theorized Heuermann may have brought his victims into the family's Massapequa Park home. Tuesday's hearing consisted of nearly 4 hours of testimony from Richard Green, founder of Astria Forensics, the lab that analyzed the hairs for Suffolk investigators. Green detailed the complex process his lab uses to extract nuclear DNA from rootless hairs like those found at the Gilgo Beach crime scenes. That DNA is then compared with a known sample, and proprietary software determines the likelihood the hair came from that person. Heuermann's defense has asked Suffolk Supreme Court Justice Timothy Massey to exclude the lab's findings from trial, arguing the whole genome sequencing method used is not scientifically reliable. Prosecutors maintain the DNA evidence should be admissible, but agreed the hearing was necessary to demonstrate the general acceptance of the techniques used by the lab. Suffolk County District Attorney Ray Tierney said Green may be the final witness called by the prosecution for the hearing that began on March 28th. The defense has indicated they will likely call at least 2 witnesses. Before we get to what's on the docket for next week, I wanted to take a moment to thank you for being a part of our growing Courtroom Confidential community. But I wanted to give a special shout out to Captain Rhett Snuggler for their fantastic review on Apple Podcasts, as well as to our CC crew members Isabel Park and Helen O'Hara White for their support on YouTube. Keep them coming. We absolutely love hearing from you. And please tell us where you are from. We are thrilled by the growth of our Courtroom Confidential community. On the docket for next week, Kimberly Sullivan, the Connecticut woman accused of keeping her stepson a prisoner in their home for decades, will return to court on Tuesday, April 22nd. San Antonio man Brad Simpson, who is charged in connection with his wife Suzanne's disappearance and death, is expected to appear in court on Tuesday, April 22nd. Suzanne was last seen outside her home fighting with Brad on October 6th of 2024. Her body has never been located. Stephen Stearns, the Florida man accused of killing his girlfriend's 13-year-old daughter, Madeline Maddie Soto, will return to court for a hearing on Wednesday, April 23rd. George Billy Wagner will be back in court for a pretrial hearing on Friday, April 25th. Wagner and his family are accused of killing 7 members of the Roden family, plus 1 other, over a child custody dispute in what has been described as the Pike County Massacre. Sean Diddy Combs is expected to be in court on Friday, April 25th for a pretrial conference ahead of his upcoming federal sex trafficking trial. And finally, please join us on our new YouTube channel, CC Live Trials, this Tuesday, April 22nd for opening statements in the Karen Reed retrial. Join us live in the chat, connect with other CC crew members and subscribers, and follow every detail in real time. We will see you there. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I'll see you again next week for another episode of Courtroom Confidential.